good afternoon and welcome everyone. Today's course is Pensions and Life Policies in the Context of Estate Planning, presented by our long-standing friends of the Society, John Bunker and Hannah Ridgement of HFS Milbourne. A few housekeeping rules briefly for purposes of this afternoon. This course is one of a number of courses available from Surrey Law Society and available to members. Do take the opportunity to view some of our forthcoming events and training on screen now. Should attendees wish to ask questions during the session, please wait until you're invited. There will be opportunities to do so throughout this afternoon's session. Or alternatively, you are also free to use the chat box, which I will keep an eye on during the course of the afternoon as well. We will hope to take a break roughly around 1 p.m. for 5 minutes, and it's important to be aware that this course is recorded and will be made available to members after the event. Today's course in particular is an interdisciplinary look at estate planning and effective use of pensions and life policies to provide for clients, save IHT and ensure better provision for the rights of beneficiaries. This new course has been specifically designed for Surrey Law Society by John, a lawyer and tax advisor, and Hannah, a financial planner from one of the Society's long-standing friends and main sponsors. I will leave John and Hannah to cover the detail in terms of what they hope to cover today, but a brief introduction to John. John Bunker is a freelance lecturer and consultant and chartered tax advisor with Irwin Mitchell. He co-edits the Law Society's IHT planning book and is known on the lecturing circuit in relation to tax trusts and all matters of private clients. He's one of the professional representatives advising HMRC on the guidance of their TRS manual, so that's something that we will touch on, I think, likely today. And until September 2021, he was chair of the Chartered Institute of Taxation Private Client UK Committee. I also know John through his representations on behalf of STEP at the Probate Users Group with HMCTS up until November of last year. Hannah Ridgement is a financial planner with HFS Milbourne, now part of the Tilney Smith and Williamson Group. Hannah provides long-term financial planning with long-term financial and estate planning advice to a range of clients, working collaboratively with tax and legal advisors, and has a particular focus on ensuring joined up approach in which she achieves her clients' objectives. Hannah specializes in life cover for entrepreneurial clients and business owners, and in particular arranging appropriate shareholder cover and key person insurance. So from here, I will hand over to Hannah and John, and looking forward to a very interesting afternoon. Thank you both.
Thank you, Kieran. Good afternoon, everybody. It's a great pleasure to be with you again, if only online. This is our agenda, what we're trying to cover today, and at various points on here, we've put in John and Hannah. In fact, a lot of it's going to be a bit of me and a bit of Hannah. You know, it's we've not done this before, but we've been very pleased to work together on this and to try and think imaginatively about how we can present some ideas on this subject. So we're trying to cover this and in the way that I've set out on this screen, and as Kieran was saying, you know, do ask us questions at the appropriate time if you've got them, or put them in the chat box. So if I just move on past the introduction to who we are, I mean, just to mention there the Law Society handbook, which Kieran mentioned. One of the themes of that was the multidisciplinary working on estate planning matters, and it's something that I personally and we as a firm have been doing for a long time. So it's really good to be working with Hannah on this. Obviously, HFS Milbourne have been supporters of the Society for some years, and really good to exchange ideas with Hannah and think about how we can bring this subject alive, trying to look at it from the perspective me as the lawyer and tax advisor, and Hannah as a financial planner. So let's get straight into our slides. As ever with my slides, and I've written most of these, but there's a part 2 is mainly written by Hannah, but a lot of it I've written, and obviously there's a lot of detail in my slides, so there's things for you to refer to afterwards. The starting point is just really to say objectives are, and client establishing what clients are trying to do, what their objectives are, is a really important kind of base point for anything you were doing in estate planning. But I've suggested in the second half of this slide that maybe there are 4 things that a lot of clients are looking to do: provide for their own security and comfort, provide for the loved ones that they care for, particularly those dependent upon them, to mitigate tax, and ensure at the end of the day the right division of assets. We'll come back to client objectives at the end in part 7. One of the important things is to keep in mind what we're trying to do all the way through, and the reality is sometimes clients do lose sight of what they are doing with specific assets, so and specific parts of their estate planning. Estate planning, as I see it, is very much an integration of 3 things: legal, tax, and financial planning. I think if these integrate well, then we can produce better solutions for clients, and that's the whole objective here. A lot of it obviously involves encouraging clients to pay us to work together, so that they're paying for both perspectives. But I think it does really genuinely work well when we can do these things together. And I've suggested on here some of the things that we're looking at. And in tax planning, it's not just IHT, but it's also the CGT and income tax planning, where we may need to liaise with the tax advisor or accountant who is doing the tax compliance side. I'm assuming that most of you on the call today are from a legal perspective. And what I would want to do is to encourage you, if you are a lawyer in this area, not to abdicate all the estate planning to a financial planner. I don't think Hannah would want that either, but
absolutely not.
Thank you, Hannah. It's very much working together, and I think we need to think about what we can each do. And in thinking what we can do, this slide just raises the question: what can you do? What can your team do? Many of you will work in teams where you've got other colleagues who can do different things, and it's good to be clear and straightforward with clients about who can do what. Introduce teams so that people know who's doing different aspects. And also, when we're working with other tax advisors, being clear who's doing what. What's the scope of your advice as a lawyer who may be doing the IHT planning? What's the scope of the tax advisor, and so on? So, who's giving the advice on CGT and so on. That sort of thing is really important. Now, with this slide, I have just 2 things I want to say, and then over to Hannah. I think there are 2 really great things about working financial planners now that weren't the case maybe 10 years ago, when most of us would have referred to them as an IFA. And the first is that financial planners are doing fee-based advice. They're independent advisors, but they're doing it from a fee perspective. So therefore, they're not based upon selling products. They're based upon giving advice, and that's a huge culture change I think I've seen over the years. And secondly, they've got great tools at their disposal, and particularly Hannah's going to talk about cash flow analysis. I think the cash flow planning is a great element, a great tool that we lawyers could understand more about, and I'm sure many of you will do that already with your financial planner advisors, but I think it's a really important part of this. So Hannah, over to you.
Yeah, thanks, John. And I would completely second exactly what John's just said there. To look at this slide almost in reverse from the bottom up, it is that culture change away from, financial advisors should not be coming into, it's quite a bold claim, but I would say should not be coming in to a meeting looking to specifically change something, sell something, recommend something. It is perfectly good financial advice to look over a client's assets and incomes and outgoings and say, you know what, you're fine as you are. It doesn't happen all that often, but it is a reasonable outcome. So what I would say that a financial planner generally is bringing to the table is they're giving the client that peace of mind and that assurance in the same way as a tax advisor or a legal advisor is going to be doing, to let them know that the decisions that they are making make sense and that there is a continuous strategy and that it's going to achieve both their long and short-term goals. Now, cash flow forecasting, which John's touched on, is a tool that I think increasingly is used, and particularly with something like estate planning. It can give that absolute confidence and sometimes almost the permission to clients to make these changes that a tax advisor or a legal professional may be suggesting to a client. For example, certain gifting pathways or structuring a will in a specific way that might be causing them some concern, perhaps because they're going to be gifting money into a trust and losing a little bit of direct control. There's often that question of, well, am I going to be all right? Am I going to have enough to live on for the rest of my life? So what cash flow forecasting allows us to do is to, in a very interactive and visual way, which can be quite helpful again for a lot of clients, particularly, but not always with elderly clients, we will plug in as much detail as we can about income, assets, growth rates that are appropriate for that specific individual and their risk outlook, and then start to map out what if you gave that money, what if you set up this trust, what if we do some life insurance, what if you use your pensions or you don't use your pensions, how can this look, how might it look in the future? And then it's something that we can revisit and work on. And sometimes I find it can really be the glue almost. It's that visualization of what their other advisors have been saying to them for some time. So cash flow forecasting, as you can probably tell, is something I think should be used in an awful lot of estate planning cases. But beyond that, it's part and parcel with what we do, which is reviewing, checking where clients are, where are they trying to get to, and then making recommendations, much as any other professional should be doing, to get them where they need to go. I'm going to touch on in the following slides some specific areas in which old policies definitely should be reviewed. But generally speaking, we are looking, thanks John, when there are specific financial goals. So again, if there is a specific objective expressed, bring us in. We can help to make sure that where possible, again, working with tax advisors, we're being as efficient as possible. We're making use of allowances, and we're not conflicting. So making sure the financial strategy is congruous with what they're being told, what they're putting in their will. I like to work collaboratively, as I sort of mentioned in my little bio. And I think it's really important that the financial planning strategy and the legal strategy and the tax strategy are absolutely not competing. So my perfect scenario is always to be around the table with the other advisors where we can. Where there are competing financial priorities, this is an instance in which we get involved quite often with estate planning, where perhaps there are blended families, increasingly a common situation, and just helping to unpick some of the emotion. Again, as impartial advisors, we are able to just sometimes cut through a little bit and very sympathetically, but try to unpick why certain assets evoke certain feelings and to reposition them back to financial instruments and tools rather than perhaps my pension, my ISA, my whatever it is that the client's holding. Another instance, again, is if there's been a significant life change. So if you're meeting with somebody to review a will, or if they've just gone through a significant change and you're aware of that, if they don't have a financial advisor, that would be a chance maybe to bring in a financial planner to check again if all of their goals and objectives have suddenly changed, what they had before that might have been working towards those old goals might not be working anymore. And then more closely on to estate planning for spouses and partners. Again, if there is perhaps an educational difference between spouses, if one spouse is very knowledgeable and experienced and has set up their own share dealing portfolio and has been running that for years, loves reading the pinks, really comfortable, and then they pass away and it all passes to a spouse who has neither the time nor the inclination to manage that portfolio, If it's left as it is, that could be a big problem. And so that's a really good time to perhaps be bringing in a financial planner. But I would be saying you want that financial planning relationship ideally to be in place before that juncture, so that you're making sure that there is that continuity and certainty in the background, rather than having it all land at what we all know is probably an emotionally difficult time for somebody when somebody's passed away. Ideally, financial plans should be regularly reviewed. So again, we don't work on an ad hoc basis very often, although we can. We tend to work on a long-term relationship basis, being that impartial advisor, and making sure that as markets change, as risk profiles for clients change, you know, as people get older, they often become slightly more fiscally conservative, not always, but sometimes. So making sure that those adjustments are made, rather than waiting until something has happened and then doing it after the fact. So that's that slide, I would say. The last point on there was just if a client says to you, oh yeah, I've got a financial planner, I would always encourage you to challenge whether it's a mortgage advisor or whether it's somebody they happen to have had a conversation with 15 years ago. If they do have one, you kind of want it to be quite active. But anyway, I'll pass back to John now, I think, for this slide.
Thanks, Hannah. And then this is where I say don't leave it all to the financial planners, and can we work together? Now, we obviously need to be clear who's doing what, and one of the big things is somebody needs to do a fact find, which is a specialist skill of a lot of financial planners. So if they can do that, but then share that, that's ideal. Can we have a joint meeting, as Hannah said, sitting around the table? And can we agree that if either does a report, that they share it with the other? Those sort of things can really help to make it work together. And then I just posit the question, is there one person who's an effective lead advisor? So is it, for example, the lawyer is the trusted advisor who's brought in the financial planner, and the client tends to look to the lawyer as their key advisor? Or is it effectively the financial planner, they're now seeing the client every year for their review, and they are the person they look to most of all, and they bring in the lawyer as needed? I just think it's worth knowing how the client sees it and get the dynamics of the relationship right. I've got two slides where I've just referred to reviewing assets that are used or owned, and the first slide is about those that are used in occupying a house or property and using chattels. And I put this up here, and you might think, well, if it's not investment, why is it on there? Well, it's on there because, as I see it, a lot of clients have got lots of bits of property, and what are they all doing? Who owns them? Who's occupying them? Is there a capital gain? I mean, I've had loads of clients come to me over the years with so many bits of capital gains on different properties, and trying to rationalize that, makes sense of what they're doing, which is their main residence, have they made an election, and so on. I think it's worth just getting your head around what they've got that is not producing essentially assets, not producing income, but is actually just an asset that is enjoyed. It may be a holiday home or whatever. It may be a client's got two properties that they move between the two of them. And the chattels, what have they got, and how does that work? My second slide then is about investment assets and just looking at what there is and how it works. I've just raised a whole lot of questions there. It's really just setting the scene. Some of the questions we would want to ask, we'd want to get established, but it's really just getting the picture. So we can then hand back to the financial planner, as I will now do, to explore what we call some of the main tools that are in the financial planner's toolbox.
Lovely, thanks, John. And apologies if anyone can hear some distortion on my microphone. I'm just trying to work out what that is, but please bear with me just for the time being. What can we do, particularly with reference to life cover? So I've just picked out sort of three of the main ways in which we might look at life assurance specifically. So we've got, oh, know where that slide's just gone. There we go, it's back. So first up, we've got term assurance, which is I would sort of say your normal life cover. So if you were somebody who's taken out life cover when you've taken out a mortgage, you've probably had term assurance. That's the normal option. You can do term assurance on either a level or a decreasing basis. Sometimes you can add level with an inflation guarantee, so it's almost increasing, but it's done for a fixed term, so you know that you're going to have that cover. The payout will be in place if death occurs or if the event that's insured occurs within those set years. I like to use term assurance in an estate planning context where a specific liquid lump sum is required. So an example of this might be if there is a particularly valued family home that's particularly wanted by children, or if there is a family company, again, that wants to be passed down a descendant line, then if there's a spouse that also requires some liquid income, but perhaps they don't want that person to inherit those illiquid assets, a term assurance policy can be a good way of getting that liquid money available. It's usually written in trust at outset for the reasons which I think are on the next slide. And then the key limitation of that cover is if the term isn't long enough. If the cover is still needed when the term is finished, it can be more expensive to reinsure at the end of the term because the individual being insured is that much older and may have medical conditions which make insurance difficult to obtain. So those really are the main issues with term insurance. And also for certain things, so I'm going to come on to gift into vivos cover, you may be over-insuring. So you may have more insurance than you need. You're paying premiums effectively for no purpose. So we need to be careful of that. The next one is whole of life cover. So again, one that people are probably reasonably familiar with. Primarily, we would use it in an estate planning context to settle IHT bills that can't be planned away. Now, that might be because the client has specific objectives that require them to retain, certain levels of control. They might not be willing to move certain things into trust, or it might simply be that there is, after all of our planning, they're still likely to have some IHT payable, and so a whole of life plan will pay out whenever death occurs. So we have that certainty, unlike the term assurance, that the individual will not outlive the cover. It's also very helpful in an instance where clients have very high incomes. So often in the southeast, you've often got people who have reasonably high defined benefit guaranteed pension income, and that can mean that they have really pretty decent liquidity through retirement. And so although paying high premiums for insurance isn't always ideal, it is worth balancing where that affordability does exist. Using something like whole of life plans can really give some immediate assurance, immediate reassurance to the estate without having a significant impact on their standard of living, which is really important. Sometimes whole of life plans are not appropriate if there are issues with income. That would be a reason perhaps not to use them. They are often available where people are in slightly less good health compared to a term assurance plan, and again, they are usually written in trust at outset. The last one is gift into vivos cover, which sort of goes in and out of vogue, but it's a type of decreasing term assurance. So you start with a higher sum, and then through the term of the policy, the amount that would pay out gradually decreases, which makes it cheaper than having the same level cover throughout the plan. And it also means that it is appropriate in the instance where you've gifted money away in the form of a pet, so potentially exempt transfer for inheritance tax, and you've got that 7-year clock that starts ticking from the date that you make the gift. And if you survive that 7 years, it's out of the estate. If you don't, some part of it gets pulled back in, and there's some IHT payable. The gift into vivos is specifically designed to make sure that the beneficiary of that gift has the money available to settle any relevant IHT that's incurred if death happens within 7 years of the gift. It can be really useful, so it's an important one to be aware of. And again, we would generally suggest, unless we are, and again, working collaboratively, unless we are speaking to the solicitor or speaking to the tax advisor and there's a good reason not to, which does sometimes happen, then usually we'd be looking to write that in trust. So if I could have the next slide. So yes, so in trust, yes or no? We would usually write life cover into trust as a financial planner. So this is purely from a financial planning perspective. We would usually write life cover in trust because it allows the beneficiaries to be specified. So it doesn't have to track the will, which can be quite important if it's for specific purpose, for example, paying off a mortgage. It also allows the proceeds to be paid before probate, which is particularly important if we're using it to provide liquid funds to settle IHT. So it can be paid out a little bit earlier, and the sum assured is generally outside of the estate, meaning that the insurance we're taking to pay their IHT bill doesn't add to the bill in the first place. So 3 pretty clear-cut reasons why we would often look for life cover to be in trust. Although again, we would always be in conversation with other advisors where they are in the mix. We would usually use the forms provided by the insurance provider. So often the insurance provider will provide a standard trust document which clients can use. Obviously that means that there's no particular additional cost for adding the trust. However, where there are complex estates or existing trusts, again, a financial planner would always be looking to make sure that either those were used or that they were consulted with to make sure that there is no unintended consequences of using that standard trust document. It's particularly important, I would say, to use a trust when you're doing life cover for non-married couples where there's no spousal exemption. Again, just really important to make sure that money is going to be available to the right person without any unintended tax consequences. And then there are exceptions. So if an insurance policy has value, so particularly for older plans where there was an investment element. Usually now when we're looking at life cover, we are looking at a pure protection policy. And what that means is that you pay your premium and there is the potential for a payout in the specified circumstance, but there is no cash in value at any time. There is no investment element. It is just you're paying for that insurance. It used to be much more common that you would have an investment element within the policy, sometimes with the aim that in the early years where the insurance is cheaper, so as a younger person, often insurance premiums are cheaper, you would pay in and part of your premium would go to the insurance and part of the premium would be invested with the view that that investment element would grow, and in the future, when insurance was more expensive, the investment element that was underlying the policy would be able to help part fund the cost. Now, for various reasons, that often went horribly wrong or didn't work out quite as intended. It does still exist. We can still look at policies like that. Whole of life plans do still exist on that basis, but that is a much older way of doing it. And so we do still come across clients with those plans, and we have to be much more careful about them and to understand exactly how they work. But for the purpose of this seminar, most of what I'm talking about is pure protection policies. I think that's all I had on that one. Okay, so another tool that we have in our arsenal as financial planners is the investment bond. I think it's fair to say that investment bonds are slightly less popular now than they have been. They are still very useful, and we do still like to use them, particularly with large estates and particularly with estate planning. But due to some of the changes that we're going to come on to around pensions and around the inheritability of ISAs in particular, offshore bonds to some extent for, shall we say, an ordinary person without massively complicated affairs or a particularly large estate may be less relevant. So broadly speaking, there are two types of investment bonds, onshore and offshore. They are both single premium whole of life assurance contracts. But unlike as I was describing before, where the main goal is the insurance, with a bond, the main goal is the investment. So it's mainly an investment contract with a small element of life cover attached. And that is quite an important distinction with an investment bond. So the principal difference between an onshore and an offshore bond is the tax treatment. Although offshore bonds typically do have higher charges, they're more complex arrangements. There are specific reasons why we would use an onshore versus an offshore bond. And of course, each client is specific. So there's no hard and fast golden rule for one or the other. But typically, an offshore bond allows you to defer tax. So if we know that we're dealing with somebody who is higher rate taxpayer now, but is unlikely to be so in the future, an offshore bond may be appropriate. And an onshore bond may be appropriate if the tax is slightly more level across the term, because they are more simple and the charges are lower. There's more to that, but without going into a full seminar on bonds, I think we'll probably leave that there. I can see John smiling, he knows how complicated bonds are. So we would often use a bond in connection with a trust. And so I've just listed a couple of the different types of trust that we would often use a bond with. So a loan trust, a discounted gift trust, and a flexible reversionary trust. Again, I'm not proposing to go into depth on what each of those is, but if that is something that would be of interest to anyone on the call, I'm more than happy to chat those through or to discuss those. In terms of when we would use bonds, they can be particularly helpful in that trust planning where we're looking to make large gifts, but also where the settler requires access to either a future income stream or future lump sum capital without completely breaking the whole structure of having made that gift, and without tripping into any gift with reservation rules. The reason for that is partly because bond withdrawals are considered return of capital. So when you invest money into an investment bond, you have the ability to take 5% tax deferred withdrawal, and that 5% withdrawal is considered to be a return of the capital. It's not an income from that investment, which is excellent. It's very helpful for long-term care fee assessments, although we do have to be careful not to pile money into bonds immediately prior, knowing that there is going to be a care fee assessment. They're alive to that. They know that's something that people might be interested in. So we have to be doing the bond for the right reasons. But if we are, and we have, then when the long-term care fee assessment happens, again, because that is not an income stream, it is return of capital, it is not added in, which is again very helpful. I've also added a note here that for professional trustees, again, basically for the same reasons, they can sometimes help to sidestep the obligation to distribute income, again, just purely because it's not income. And then they can also help to simplify administration by reducing reporting. So some good features for investment bonds. So definitely very useful tools to have.
Hannah, could I just say, I think that's a really valuable point, because there are some smaller trusts where doing annual accounts and tax returns really just doesn't make sense, and just the simplicity of being able to have it in a bond actually really can work quite well.
Absolutely, yeah. And when we're talking about sometimes with bonds, one of the reasons they're perhaps less popular is because they can be considered more expensive, but if they're saving money in terms of the wider charging perspective, then that slightly additional cost is well worthwhile. Okay. So pensions, of course, are one of the most common things that a financial planner will be looking at, will be talking about, will be working with. For most people, other than their property, their pensions are often one of their largest investments. So pensions in general are typically written under a trust. So most pensions are already effectively in trust. As a result, pension death benefits now are usually outside of the scope of inheritance tax. We're going to come back round to this, so I'm not going to dwell on it, but it is a really important feature of pensions. Provided that plans offer beneficiary or nominee drawdown, and that's a big sort of if or but, because these changes with pension inheritance, and again, we're going to come on to this later, they came in as a change, as a big change, and pensions that were written before those changes came in, sometimes it's not possible for them to provide the flexibilities that were then enabled. So without going back and changing that pension, and that typically means transferring it, these may not be available as features. But provided that they do offer that, what can happen is that the person inheriting the pension death benefits can leave the money effectively within the pension environment, which is particularly valuable if they then don't need that pension during their lifetime. So it can remain tax advantaged and then pass on to subsequent beneficiaries, with the ability that it can be dipped into during that person's lifetime really easily, and often very tax efficiently, but without the need for further gifting or further planning. It can just stay in the pension, and there is confidence that it will then pass down to future generations. So really important to check old plans to make sure that is available if it's being relied on, but as a rule, very straightforward where it is. Okay. So last couple of points on this. So around surviving spouses and lump sums, providing, and this is always an if, it's always difficult to be definitive with financial planning as with tax and law, but providing that there are other assets and income sources available to a surviving spouse, I would often be discouraging that spouse from purchasing an annuity, for example, with that pension death benefit, if they don't need it, if they don't need that guaranteed income, because it's locking up then what could be a really effective way of gifting to subsequent beneficiaries and subsequent generations. And we would be instead suggesting that it stays in the pension. Again, don't take that return of fund, don't take the whole pension on day dot, because you can leave it in there. You can have it down the road if you want it, but it means it won't fall into the estate on second death, which is really important. I've also mentioned here around blended families. Pensions often can provide a really useful way of making sure that if, for example, we were using an immediate post-death interest trust, if there's going to perhaps be a delay to children, adult children coming in effectively to their inheritance, because it's going to go to a surviving spouse first and then it's going to come to them, the pension can give a really useful way of granting access to some capital, to some wealth directly before then subsequent assets, before the house can be sold, etc. So hopefully that all makes sense. Any questions at all? I'll have a look in the chat. Do come off mute and ask if you've got anything.
Don't think there's anything at the moment in the chat box. Anybody want to ask a quick question at this stage? If not, I could just go on to a brief reference to TRS. Thanks, Hannah. And hopefully this will just tie in with what Hannah's been saying about the different types of life cover and so on, because we thought it was worth just saying briefly a reminder of the different ways in which life policies and pensions are treated in the TRS provisions. And of course, a reminder that if you've got any kind of tax liability, you're within the 4 MLD provisions for registrable taxable trusts. So what I'm concerned with here is primarily registrable express trusts, where there is no tax liability arising. And these are the DRIP regulations causing us all such fun running up to the 1st September deadline. So I want to go through and look at the 4 exclusions for pensions and life policies. And first of all, to compare paragraphs 3 and 6 in the schedule 3A, which deals with all these exclusions. Remember the principle, you have to register an express trust unless it is within an exclusion. So what are the terms of that exclusion? So first of all, pension schemes themselves are excluded because they're so well regulated. That's paragraph 3, but not a pilot trust set up to receive pension death benefits. So if you've got that arrangement, if that pilot trust was set up before 6th October 2020 and has a value of not more than £100, then you've got a specific exclusion. But anything on or after 6th October 2020 must now register, whether it's a pilot trust set up to receive a pension death benefit or the proceeds of a life policy when that pays out. So in either case, those have to be registered. And of course, if you've got a trust that was set up to receive pension death benefits, when it does get those benefits, then you'll have to register within 90 days of the receiving the funds. That's the relatively easy bit. The more complex bit is insurance policies, and particularly because of the possibility of cashing in some of it, the possibility of having some kind of surrender value. And so here I want to give you the wording for paragraph 4 as it is now amended by the new statutory instrument that came out relatively recently. And the wording of that seems to exclude any reference to something that might have some surrender value. So it talks at the top there about paying out only on the death, terminal or critical illness and so forth. Now, when I read that, I thought if something could pay out with a surrender value, it wouldn't be within paragraph 4. Not exactly, the revenue say. So I'll explain a bit more on the next 2 slides quite how that works. But essentially, as I've said in the middle of this slide, go back to Hannah's categorization, the term assurance policy, the whole of life policy, those essentially can be excluded if they are within paragraph 4 and we've got a potential surrender value that's not going to scupper it, as we'll see in a moment. But most other types of life policy will need to be registered from the outset. One important point to note about paragraph 8, some people get confused. This is the paragraph that refers to a 2-year window before you need to register. But this is only applies if you are within the scope of paragraph 4. So this is just where you've set up a pilot trust effectively to receive, or a trust to receive the proceeds of a life policy that is covered by the terms of paragraph 4. If it's not within those terms, then you haven't got that exclusion. And if it's not then within paragraph 4 or paragraph 8, all other life policies have to be registered on the TRS from the start. And that's within 90 days of being created. So I hope that's helpful just to clarify that. But let's look at this difficult issue of surrender values. And I've quoted a large chunk from the trust manual, the TRS manual 23030, which deals with this. We hoped, they took a long time coming up with this because I'd raised the point with them back in the summer. They'd given me an email in June and then they said we're going to do it in September, and then they didn't, and then it didn't come out till December. So it took them 6 months to produce this, and we hoped it was going to be nice and clear cut. It's not quite as clear cut as we would have hoped, but essentially we look at the purpose of the policy. The middle paragraph here, the middle of my 3 sort of black bullet points, trust holding policies with surrender values can remain excluded until such time as it's actually surrendered. If a policy is surrendered, the cash sum is retained in the trust will be required to register from that point. But we set up above, the other bit of bold type above, the possibility of a policy being surrendered does not in itself mean that the trust holding that policy cannot qualify, because HMRC accepts that surrendering a policy does not ordinarily constitute a payout from that policy. So is it anticipated this is a normal part of it? Now, it's slightly dancing on the head of a pin. They've given an example with Iqbal down the bottom and a whole life policy. Essentially, if you're looking at a whole life or a term assurance policy, you're likely to going to be okay. But read what it says about Iqbal there and that example, because it's not primarily set up for the purpose of cashing it in. And then it contrasts it with the other situation, which is where cashing in is part of the purpose of the policy. And clearly that's the case with an investment bond, that you can cash in, as Hannah was saying, it's a treated as capital when it is cashed in, but that's part of having a bond. And that is the case with so many other life policies as well. So if it's designed to provide some sort of regular or periodic payments to the policyholder in the form of surrenders, then that is not going to be within paragraph 4, and therefore there is no exclusion. So I've set that all out there, and again, they've given an example from Margaret, which I've quoted there, and that's an investment bond example. So just to illustrate how the revenue are defining what does or doesn't get an exclusion for the purpose of the TRS. The conclusion from that really is you need to look at the purpose and intention of the policy, and is it essentially protection, or is it essentially investment focus? But where the dividing line, it's maybe a little bit uncertain, but this is where we can work with financial planners to establish what the purpose is, and therefore whether we have to register or not. If anybody has any questions, please do ask that now, or put something in the chat box. Don't think there's a question there at the moment. And subject to any question you may have, what I'd like to do is then just try and see if we can cover part 4 before we have a little break for a comfort. Okay. Because we then need to get on to some of the meat of the planning and look at pension death benefits. Hannah, would you like to come in and say a little bit about the first couple of slides in part 4?
Yes, thank you for bringing me back in. So I just on these would just add that this is sort of one of the biggest changes, certainly I would say, in terms of the financial planning approach to estate planning that's happened probably in very many years, certainly during my time, which is the significant change. And apologies, my cat's going to walk past me now. A significant change was that rather than pensions being purely used for retirement, because there was this extremely punitive tax charge on any pensions that weren't utilised, that fell away. And so now having the death benefits used for succession planning, for legacy planning, makes really good sense. And there's a quote from Smith and Williamson, now part of that group, where they're saying quite rightly that our pensions now the most tax effective trust funds ever, because for the vast majority of people now, provided the pension isn't needed during a member's lifetime, they are there as a really, really effective way to pass money down the chain. John, did you want to also talk about this slide, or do you want me to move on to the next one? Oh, you're on mute.
Classic mistake. Sorry. Yeah, I mean that's fine. We can go on, but I think one thing I would just say is that I think it is quite generous. I think it would be fair to say that some people think that there may come a time where this tax relief may not be as generous as this. When George Osborne announced this to a Conservative Party conference a few years ago, I think it took everybody by surprise. It was the rabbit out of the hat for dramatic political purposes. But but I think while it's there, it's so good, we have to use it. So on to you, Hannah. Yeah,
absolutely. And my 2 pennies worth on that would be, I think that while we have the annual allowance and the lifetime allowance constraining what people can put into a pension, there is a chance this stays. I think if we see too much change with lifetime allowance, if pensions became a bit more unfettered in terms of how much could be put away into them, we might start to see constraints in terms of how much then could be passed on efficiently. So it will be interesting to see what does come down the line in the future. But in terms of pensions, and we are using some acronyms here. So I just wanted to point out, we're using DB to mean death benefits, but of course in the pension world, DB can often mean defined benefits. So final salary schemes, things like the NHS pension, the teachers' pensions, and it's worth pointing out that the death benefits for a DB scheme are fundamentally different. So just one to be mindful of. We here are mostly talking about defined contribution plans, which is your money purchase plan, where you're paying in and you're getting an investment pot that is then usable when you retire. And there's no specific income that is being guaranteed down the line. So really great flexible access to DC pensions during a lifetime. You can take the whole pot if you want. There was the famous, I think it was a Daily Mail story about buying a Lamborghini. I've yet to meet anyone that has bought a Lamborghini with their pension, but it's theoretically possible. And as we've noted here, HMRC are taking considerable amounts in tax payments because it's added to your income. So if you take £120,000 out of your pension from the taxable income portion, that gets added to your income tax bill, and you are going to pay a decent whack of income tax on that withdrawal. So whether it's in somebody's best interest to do that or not should be looked at with a very close eye, but it is there as an option. And of course, now everyone can use income drawdown. Previously, there were limitations on who could access their pension flexibly in retirement. You had to meet certain thresholds of guaranteed income from other sources before you were allowed to draw on your pension flexibly. So this opened it up then to everyone to be able to do that. It means that less and less people now are buying annuities, those guaranteed income for life contracts, which offer a set rate at outset and generally can't be amended down the line. And it can mean for many people, they are able to draw a higher, albeit potentially not sustainable, during early retirement when they need it. So it has provided people with access to money that they do need. And then the major change in terms of the death benefits is that it allows people to pass on undrawn pensions. Again, not all older pensions can accommodate the full range of death benefits that are available. Some old plans will insist on either annuity purchase by the beneficiary or the return of fund, which is just that they will pay out all of the money from the pension plan out to the beneficiaries. It's out of the pension then, and it's with them. So it's not necessarily going to go through the estate, but that money is then out of the pension world. And if it's a decent amount of money in the pension, it might take them a few years to put that back out of their subsequent estates. So it's really important to find more modern contracts that can facilitate, where it's appropriate, having that ability to leave the money within the pensions. And then lastly, it's that defined contribution pensions can now be paid to any beneficiary. And again, this is a key difference with defined contribution versus defined benefit pensions. Defined benefit pensions still very much do not have this as a rule, whereas with defined contribution pensions, there's no requirement anymore that the beneficiary has to be a spouse, a dependent child, a relative of any degree. It can truly be to whoever the person chooses. And then this I've touched on already, so apologies for repeating myself. But there are three major ways in which pension death benefits can be paid. Again, very much subject to individual scheme rules. So this is one of the main things that as a financial planner I check for older pensions for my clients is what actually is available from this scheme. So firstly is lump sum. That's the most common. Most schemes will facilitate a lump sum payment to a beneficiary. The second one is the flexi access drawdown. So income drawdown payments from a beneficiary, but crucially, they don't have to take any income. So it can be moved into a flexi access drawdown beneficiary or nominee plan, and then it can remain invested, free to pay pension income if they want it in lump sums or not lump sums, but it's there, it's still in a nice flexible pension. Or then lastly, there is the option for an annuity or a scheme pension, which is sometimes still appropriate. scheme administrator must retain discretion on the payment. So I think we're going to touch on this more later in the presentation, but it's really important. I can't overstate this, that the pension trustees must not, unless we want it for a specific reason, they must not usually be given a binding nomination. And some schemes do not make this easy. So there's one particular pension scheme that I won't name, but they send to all new members 2 sets of forms. One is an expression of wishes form, which is what we would expect, so non-binding, but an instruction of their intent for the trustees to consider, and they pair with it a binding instruction letter, and they say to the client, send either one back. Now, if you weren't being advised by your lawyer, by your tax accountant, by your financial planner, you might well say, as a layperson, well, I know that I absolutely want my pension to go to my wife, or I absolutely want it to go to this person. And you might be inclined to send back that binding nomination, and in doing so, potentially lose the IHT exemption for the pension. So again, just a really, it's a bear trap that people can fall into. So it's a really important one to just be making sure that they've completed the right form, and if they haven't, that perhaps they change that. So that's probably everything on that slide.
Thanks, Hannah. That's a really valuable bit of practical advice, because that's horrid. I hadn't come across that myself, but that's really useful. Just a final thing on there, perhaps say the lump sums can be paid to any beneficiary, whatever nomination is left, and that's going to tie in now with our next slide, because we come to who can get what. The categories: dependents, nominees, and successors. So dependents is the old category of people who were financially dependent on the deceased, but now the concept of a nominee, who is somebody nominated by a member or by the scheme administrator if there's nobody else who is a dependent or a nominee, but only if there's nobody else left. And then a successor who can inherit on the death of one of the others, one of the previous categories, who can be nominated by a dependent, by a nominee, or a previous successor. Now, we'll see a good practical example of that from on a couple of slides just coming up. But just to get clear, the basic tax treatment, and that is that, and Hannah was very kind earlier on in saying our slides, and it's actually my use of the initials DB for death benefit when it's slightly confusing. So, but it's a very good point. The DB can mean 2 things, but here I'm talking about death benefits, and the death benefits, if it's a death under 75, you've got the different tax treatment that there is no tax charge on a lump sum or a pension, as on my 3rd blue bullet point on this slide. And then the 75 or over, pensions are then paid at the marginal tax rate of the beneficiary. Lump sums are taxed at the beneficiary's marginal rate of tax. Now, so there is a different situation depending upon whether somebody dies under 75 or 75 and over. In other words, a bit of compensation for dying relatively young. The key thing at the bottom, that one has to be paid or designated to draw down within 2 years from death. As Hannah said, you don't have to actually start taking in income. If it's just designated to draw down in a flexi access drawdown, then it can be left there, and no income needs to actually be taken for the time being if it doesn't suit the beneficiary to do that. Then the reference here to an SPT, to a spousal bypass trust, which we will say more of in the next part, in part 5. But there were some sort of temporary rules for spousal bypass trusts, but essentially now what we've got is a situation whereby if you've got a spousal bypass trust and a payment is made to them, you pay the 45% income tax charge on the distribution if somebody's died 75 or over. But go back to my previous slide, if they died under 75, then there'll be no tax payable on the lump sum. So that is one situation where there's a real tax advantage, and therefore that can be carried through to the SPT. But assuming it's 75 or over, you pay the 45%, and then when it is distributed to a beneficiary, at that point you can claim a deduction of tax and claim it back. So here is the if you like, the cash flow problem, that if you've got a death 75 or over, you've got this big chunk taken out, this 45%, until it's distributed, and the tax credit can then be used when it's distributed. Now, this is my example, and Kieran, if it's okay, if I just carry on with this and just for a couple of minutes, and then we'll take a break, because I think
Absolutely.
this illustrates. Thanks. This illustrates the problem, because this is I've borrowed this from John Woolley, who's a really good writer in this field, and in the journal Private Client Business, he gave this example some years ago, and I just think it makes the point very well, because in this case we've got Harry with a wife, W, and 3 children, A, B, and C, and each of them's got some kids, but B's only got 1 child. But the problem is, as I say later on in this slide, that he fell out with B some years ago. So at the moment, he's not including B and B's child, BA, in his wishes. So he's got a letter of wishes where he has asked for the pension to be divided between A and C and their children. He's also suggested income or a lump sum for his secretary S. Now, when it comes to it, the widow and A and C ask the administrator to make provision for B and for B's child, BA. And they've said, we want fairness to be done here. He may have reconciled, or they may just want B to be provided for in any event. But they've all agreed S doesn't need it, she's fine, and W didn't need it either. But the problem is, we go on to the next slide, that we see that there's a problem because Harry hasn't named B as a beneficiary. He isn't nominated, so he's not able to benefit under this scheme in his own right. All he can have is a lump sum, as we'll see in the middle of this slide. So the scheme administrator wants to divide everything as requested, and A's children, C and C's children can each have 1/8, and they can choose how they have it. They can have a lump sum, they can have a flexi access drawdown, that's fine. But B doesn't have that choice because he wasn't nominated. In B's case, B can only have a lump sum. The scheme administrator can't nominate B as a member unless everybody else has gone, unless all of A and C and their children and so on have died, and there's nobody else left. So, but he can get a lump sum, that's all he gets. So there's no flexibility, there's no flexi access drawdown option. And I think that just illustrates the problem. And it's a practical problem because, we all know clients do fall out with some of their children. And in this case, Harry may well have been reconciled with B, but he's forgotten to change and to appoint or to nominate B as a beneficiary of this pension scheme. So, do be aware of the consequences of not nominating a potential beneficiary, and we'll come and see the value of nominating somebody, but then actually keeping the flexibility over the question of who's named in the letter of wishes. So I think if we finish with these 2 slides here, obviously a scheme administrator is not bound to follow a nomination, but it's important that the member must nominate all that he or she might wish to benefit. You can include in their grandchildren, and if you want to, you can include children-in-law. That's potentially more a sensitive issue, but there may be good income tax reasons, because you may have a daughter who's a high earner and a son who's a nurse who never going to be a high earning taxpayer. So you want to pay it out to the son-in-law rather than to the daughter for income tax reasons. Now, if that's the case, it's good to have the son-in-law in that situation nominated as a potential beneficiary. This slide then finishes by saying the 2-year period is vital. We've got the 2 years, we've got to sort it out in that time, but it's great we've got 2 years. I mean, that is a great thing. Lawyers, we're used to variations, we're used to that whole 2-year flexible period, and we can use that period working with the financial planner to decide what we're going to do in that time with regard to our pension death benefits. So if we nominate all that we might wish to benefit, and then have the second half of this slide a separate letter of wishes about how that are divided, between all those who've been nominated, how are we going to split it up? And that's where Harry could have nominated B and then divvied it up between A, B, and C, and then set out the criteria and the circumstances. We can specify shares, but this is the art of doing the letter of wishes, which we'll comment on more in part 5 after our break. It is there's a great art there, and I've just posited a couple of questions. Do we want to ask the pension scheme trustees to refer to anyone particular? Is it the executors of the will who are going to have the overview? If you remember, going back to my client objectives at the beginning, my 4th objective was, how are we going to split things at the end of the day between everybody involved, all the potential beneficiaries? This is the critical moment where we're saying, particularly with blended families, how are we going to split things at the end of the day? Are we going to name a spouse and children to consult? Is it the executors? Who is going to have the detailed wishes and is going to have that opportunity to guide the pension scheme trustees about how they split everything up? Okay. If we can pause there, have our 5-minute break at 6 minutes past 1, that will be lovely, and we'll see you in a moment to carry on with spousal bypass trusts. Hannah, so welcome back, everybody. Hannah, do chip in at any point on part 5. I mean, I'm covering things here which are very much a real interaction between my side and your side. So please do chip in at any point. But what we wanted to do was to sort of take stock of spousal bypass trusts and have a look at where they are in the light of the pension death benefit provisions that we've just outlined and the choices therefore that are open. And to ask the question, why would you use a spousal bypass trust? Some of you may have set those up historically quite a few times. Should you still be using them, or should you still be setting them up now? I mean, I think one has to say that the advantages of them are much less, given the flexibility of flexi access drawdown and the fact that you can keep things within a pension scheme as a structure with all the benefits of that. And I've said there the great value in FADs and the tax-free environment once you've designated to a family. But we have to be careful not to throw the baby out with the bathwater. And the fundamental problem that a flexi access drawdown is not as flexible as a trust that has flexible beneficiaries, including a spouse. The spouse cannot benefit if you designated to the family in drawdown. So therefore, you've got to make your choice and see what are the circumstances overall. Why might you use them? I mean, essentially, SBTs are protecting spouses in case they might need to benefit. The value of an SBT is you keep the assets outside of an estate for inheritance tax and also for care fee purposes, so that that asset is not going to be in the hands of the spouse, either for their personal tax IHT liability or for care fee purposes. You're protecting the capital for the long-term benefit of the right beneficiaries, and particularly if there are any financial problems. And one of the questions obviously one would want to be exploring with clients if you were looking at an SBT, whether you kept it, is are there issues within the family about divorce or financial problems, possible bankruptcy, and so on. I've said that there's an IHT benefit out of keeping it outside of the estate, and there's a limited tax disadvantage with an SBT. Obviously, you have got the cash flow problem of the 45% income tax if you die 75 or over. But particularly if somebody dies under 75, an SBT has a particular value. And I hope that makes sense to you as well, Hannah. Sometimes if you've got an existing one, you might want to wait and see when somebody dies and whether in fact they were to die under 75, in which case all the more reason perhaps to use that as a vehicle than if they died over and there was a tax charge at an early stage if you distribute to the SBT. One of the advantages of using an SBT is the facility for a loan, to be able to lend a beneficiary, give them access to funds, but still outside of their estate. And provided it is repaid, and I've just referenced there the provisions that were brought in a few years ago for Section 175 of the IHTA about making sure you repay a loan, but if you do actually repay it, it can be deducted. And protecting the capital because there is a loan that has to be repaid. I've said if the member down the bottom here, if the member dies under 75, the SBT may be ideal. But if one spouse, and I've said here, if one spouse dies under 75 and the second spouse dies over 75, there's a particular value in using that structure. Now, so we need to really think through some of the issues we need to consider in looking at a spousal bypass trust. And clearly, whoever's doing it, and we come back to the question of who is the lead advisor, and who's giving the client the main advice here, and really working together between the lawyer, tax advisor, and the financial planner. But being clear on, as I say on this slide, who are your clients? Because in many cases, as a lawyer, one finds oneself acting for a number of different people. You act for the surviving spouse, but you also act for the executors of the will, and you also act for the spousal bypass trust trustees. That's the risk. You act for a number of different people. You may act for the children as well as for the surviving spouse. So is there a conflict? Is there a potential risk in terms of the different people? And one of the things that I would want to flag up as something people might want to consider is, if you were considering whether to distribute out to beneficiaries, for example, because you felt somebody died over 75, there were tax advantages of designating to draw down for those beneficiaries. Whether one could at that point say to a surviving spouse, that, okay, we act for the spousal bypass trustees, we act for the will trustees. Our job in doing that, our key focus, is to put into effect the wishes of the deceased, the person who took out the pension. And therefore, it's necessary for a spouse or partner to take independent advice. Now, in that situation, we're not saying just go off and find somebody. We can help them. We can set out the situation. We could set out in a letter what it is that we are looking to do. So long as you're not advising, so long as you're not making, trying to suggest what somebody should do, actually the possibility of having a helpful letter summarizing the situation, so that a surviving spouse in that situation can then go to another lawyer and take advice, or go to a financial planner and take advice. It may be a mixture of both, and say, look, this is what the situation is. What should I do? I mean, in the situation where your spouse has died, going back to one of our earlier slides, that's a really important point for a surviving spouse to make sure they have proper, good, independent financial planning advice. Because, the whole situation has changed now. We've got one life, all the funds potentially available from different sources for one life. Which source are we going to draw on to meet those needs? We'll come on to some specific cases in relation to pension and ISAs, and what we might say in a little while. But just addressing this issue about the retainer, about what we're saying to a client and getting independent advice. And also about who takes responsibility. What is the nature of the responsibility that the lawyer stroke tax advisor is doing? What's the financial planner doing? If there is a separate tax advisor who is the person who does the personal tax compliance, who's doing what? Be clear who has what responsibility, and how you're sharing that responsibility between you. And working with financial planners, obviously this is the classic situation where you need to work together. And as I say in the middle of this slide, a financial planner should understand the scheme terms and what the administrator needs. This is where, if I'm working with Hannah, she clearly has a good grasp of how the pension scheme trustees will work, and therefore will be able to see what they need. And what are we going to do with our nomination forms? What are we going to do with a separate letter of wishes? How are we going to express these things? That's the sort of thing that I don't think any lawyer should be doing on their own. They really should be working with a financial planner on that to make sure that we are doing it together. We are sharing our understanding of how this works to get together the wishes of the client about how things will be divided and what different resources can be used, but always keeping in mind the fact that the pension death benefits may be one of a number of sources, and we need to be aware of those different sources that could be needed for or could be used for providing for a beneficiary. Anything you particularly want to say there, Hannah?
No, I'd agree exactly with what you've said there. Certainly, I think just making sure that those forms are completed by somebody that knows what they're looking at is just really important. Obviously, usually that would be a financial planner, but they can be tricky, and sometimes they're not standardized across schemes. They're barely standardized across individual providers, so they really can be, if you think you're pretty au fait with one, the next one you see might look similar but be quite different, so just really do be aware of those.
And your cautionary word from earlier on about a life company that sends out 2 forms, which is just shocking. It's just to send out one form, which if you sign it would actually defeat the whole IHT purpose, is just beggars belief. It's
one of the big occupational ones as well. There's a few members of it. It's not a small plan.
Oh dear. Okay, so in looking at the nomination forms and letters of wishes, this is just to revisit what we said earlier, that we want as much as possible to have all the potential nominees named on the nomination form, and then have the separate letter of wishes about how things are divided, and then the issue about who the pension scheme trustees are going to consult with. Who are the people? The SBT trustees, the executors of the will, the widow, the children. Who are the people who are going to be consulted in that period? And also, one of the points I've made here in bold here is making sure we make good use of the 2-year period. We don't have to rush into this. We haven't got to do this distribution within 2 months of somebody dying. We've got time to take stock and have a look at this. We've got time fundamentally, if there is a surviving spouse, for that surviving spouse to have an independent financial planner look at their circumstances, review everything with them, and see how they stand. So, really important to use that time to make sure that we've got sufficient assets and income for security and comfort, and that we're using the most tax effective. So we go back to my 4 criteria at the beginning, the 4 aims. We're looking to provide for ourselves, for our loved ones, for doing it tax effectively, and also that at the end of the day we get the right balance of who gets what. Okay, and then what this does mean is that we have fuller letters of wishes. And I think one of the things about letters of wishes, you can then deal with some of the issues that are important, particularly with blended families. So the balance between the surviving spouse and the rest, how we get that, how it ties in with the other assets I've been referring to, the other sources of funds. What does equality within the family mean? And if I given the example here, what if you've got 3 children, one has no children, one has 1, one has 3? Are A, B, and C equal? So are they basically, are you saying each of them's got a third and they can then divvy that third however they like? So obviously A can keep it all to him or herself, B can share it with their child and so on. Or are the children in the mix? The example we gave earlier on, the John Woolley example from Harry, he had everything was divided there in 8 shares between the children and the grandchildren. They all had an equal share, the grandchildren, with the children. Is that something you want? Sorry, the reference number there for Harry is wrong. I've said C 978. It should be 478. Apologies, but that's about the sheer who gets what within the family and what is the end result you're trying to achieve. And those letters of wishes, which should be kept under review, so that when we're reviewing wills, we are looking at those and making sure that they are still right, or whether they need any change at that point. And also, what's the effect of doing things tax effectively? How can we do that? Because somebody in the family might well be saying, actually, we can do this much more tax effectively. If only we did this, it would really work for tax purposes. But somebody says, but that's not what Dad said, or that's not what Mum said for fairness purposes. So, the letters of wishes need to get these things right. These are sophisticated documents that need a bit of care and attention. And that's where I do think the 2 heads are better than one, whether they're drafted by the lawyer or by the financial planner. The other has an input in this and taking it as part of the overall. Any other thoughts there before we go to any questions, Hannah?
No, just to back up what you were saying in terms of it comes back to the fundamental objectives. What are they trying to achieve? Sometimes it might be not including the children at all and cascading directly to the grandchildren. But that's the bit which, as John said earlier, whoever the lead advisor is, whoever really has their finger on the pulse of what are these clients trying to achieve. As a financial planner, I can fit in with that. If a lawyer knows exactly what this client's trying to achieve, we can help with then making sure that happens, or vice versa. But I think really it's just always coming back to, not allowing ourselves to run away. And John, you have to forgive me, but not allowing ourselves necessarily to run away with tax efficiency for the sake of tax efficiency. It's got to come back to, why are we doing this?
Absolutely, and tax efficiency is not everything, and getting that whole picture right is really important. So and I think one of the things I think we're going to, I'm going to come on later on to reviewing all that passes on death. So we will come to that in a minute. But shall we just ask a question? Any questions at this stage? Anybody want to unmute and ask a question? Oh, something in the chat box. What do you do if the letter of wishes has been mislaid by the trustees? Oh, goodness. Good question, Hannah.
Well, if you're using a financial planner, the financial planner should have a copy of it on file. So that would be an advantage of working with a financial planner. I would have a copy. So that would be probably quite helpful. But failing that, the trustees, because they have discretion, will then look to make a decision. But so it would effectively revert. And my understanding would be that often what they will then do is look for, is there clearly a dependent spouse? Are there clearly dependent children here? They will run through what I would suggest you would expect them to do. Of course, the trustees have an obligation. So that's generally how it would work. But I've certainly never come across a case where that has been mislaid, where it's been submitted. But for all of my clients, I'd have it on file anyway.
And I suppose it's also worth saying that if you're a lawyer who is dealing with will and you're keeping the will in the strong room, that actually it's worth keeping the pension document, copies of the pension documents there as well. So you've got belt and braces, and so that you've got that as well to refer to if need be. I mean, it has been known for life companies to lose trust documents, so sometimes it's useful to have something you can magic to produce to say, actually, this is this is the trust document, and this is what we've got here. Okay, let's go on then, and let's look specifically at some of the issues in relation to the residence mill rate band and how that works, because I'm going to start this and bring Hannah in just a moment. But the RNRB £2 million threshold, it seems to us, gives us some whole new issues to think about, and in particular the fact that when we're looking at this, I mean, I've just got some basics on the £2 million taper threshold on this slide, and the fact that the estate for the purpose of the 2 million includes aggregated trust interests, but doesn't take any regard for APR and BPR. So that's what it does include. The big thing is it doesn't include pension death benefits written in trust. So assuming you haven't got a binding nomination. So so that is the huge thing that is a big new factor to think about here. Don't forget, as I say at the bottom of this slide, that the taper also applies to any brought forward transferable RNRB. So that's also going to the same is going to apply to that. So I ask in this slide, can we help clients with, say, 1 to 5 million in joint assets to look at how they plan with regard to this £2 million taper threshold? Now, some of you may think 5 million is a bit over the top, because if you're going to get below 2 million, surely somebody with 5 million is too much. What I would say is that if you've got somebody with 5 million, they plan early enough, and how they're using their assets, it may well be that when the time comes, that they can actually look at qualifying because they are below a £2 million threshold. So clearly, will planning is crucial here, and looking at the possibility of variations and how we do that in the 2 years, that our magic 2-year period. But so that's a big part of it. But then there's a big question about how we use assets during lifetime. And I think that needs some rethinking in the light of the 2 big developments, pension taxation, and also what we can do with ISAs for spouses. So what I then say here is I do think it's important to look at reviewing the whole use of assets, everything that the client has, including pension funds. That we lawyers need to look at this and not just leave it to financial planners, that it's part of our estate planning advice for our clients to think about how they are using their assets, and to make a point of being proactive in liaising with financial planners to see how they're seeing things, what they're doing, and so forth. And pensions in trust are not part of that £2 million limit. That is a huge factor. So long as it's not a binding nomination, it's in a separate pot. And all the tax benefits we've outlined in part 5 are there to be developed, to be explored if we can. And therefore it raises the question, can we help, say, surviving beneficiaries, particularly surviving partners or spouses, to consider spending other capital, which is in their own names, in their estate, to meet their living needs, rather than actually drawing down the pension, and leave as much as possible of the pension with the favourable tax treatment you can get with pension death benefits in the pension pot. It's got the financial planning benefits of being in a pension pot, but also potentially the tax benefits there as well. So that's the big thing we want to look at. Do you want to add something to this slide, Hannah?
No, you've covered everything I'd say there. I'll chip in in a minute.
Okay, great, lovely. The importance here of seeing the whole picture, of seeing everything that will pass on death. Now, some of you lawyers may be within the Law Society's WICS scheme, and if you are, you'll be familiar with the WICS protocol, which talks about looking at all the assets which will pass on death, and reviewing all of that. So all the trusts, all the life policies, all the pension nominations, anything owned as joint tenants that might pass as a surviving joint owner to the surviving joint owner on death. Look at all of those things, all of the things that will pass in the estate, but all the things that will pass outside of the estate as well. Now, I say this, and I say this from some experience that, from my perspective over the years, I've found clients have often lost sight of things they have taken out, particularly in the past when people didn't have such regular reviews with financial planners. They'd often get financial planning advice, but then forget what they'd set up, what they'd taken out. And there will still be clients who are not looked after properly with an annual review and so on, who will forget that they had something, they had a life policy written in trust, for example, that they've forgotten the consequences of it. Now, the cautionary tale is this case of Herring and Short's Financial Services, which is a case where there was a negligence claim should the lawyer and financial planner have advised on the terms of the trust. And basically what happened here was, the client absolutely forgot they had a life policy written in trust. And some people got some benefit as the beneficiaries of that trust. And had the client remembered the terms of that trust, they would have changed their will. They would have had different provisions in their will if they'd been reminded of the people who were getting a benefit under the life policy trust. Now, they should have remembered, but this is where people do forget. And in this particular case, neither the lawyer or the financial planner were actually liable under negligence on the facts of the case. But it's a little reminder that people sometimes are looking for somebody to blame. If you should have told me this and you didn't tell me this, well, you should have known. But actually, who should have what? That's the question, which is often the question in any negligence claim. And should you have done something? So, just remember Herring as a cautionary tale for us all, lawyers or financial planners, that just to be clear that sometimes there are things that slip through the net and people forget about something which has a consequence, because it's part of the picture of who gets what at the end of the day. My fourth of my kind of criteria or objectives for the client, who's going to get what at the end of the day. Hannah, do you want to say anything on that?
Again, just to really second you on that, I think that's a really interesting case in terms of the sort of the bit of blame that can creep into these things sometimes, and it really does highlight the need for these regular reviews. I mean, just speaking from personal experience, I've had clients that have forgotten that they've taken out critical illness policies, or they've forgotten that they've and they're things that they're paying for every month, and they've just plain forgotten that they exist, and we remind them of them every year at the reviews. But when we meet new clients, it's amazing what comes out of the woodwork, often over the first year or 2 years of working with somebody, as they go through their filing cabinets and suddenly find something they did 20 years ago that actually is still in force and does have a bearing on their overall position. So yeah, I think that point again just cannot be overstated, the need to really dredge everything up as much as possible.
Lovely, thank you. So I want to just share with you now 2 situations where, as lawyers, I think you can say to a client, stop, before you go any further, just hang on a minute. One of these in relation to pensions and one in relation to ISAs. And I think there are 2 situations we may come across when we're talking with clients. So, for example, the first one is you're seeing a client about their will, and they happen to say in the course of their of the conversation, "Oh, I'm retiring in September, and I'm going to take my pension. It's going to be so lovely. I'm going to play lots of golf and travel Europe, and etc." And you want to say, "Stop! Hang on a minute. Before you take that pension, have you taken proper financial planning advice?" And they may say, "Oh yes, about 5 years ago I saw this advisor who told me, and I've got it all set up and it's all." Hang on a minute, you say, that was 5 years ago. This, we want to take some up-to-date advice, particularly in the light of the R&RB rules, in the light of the pension death benefit rules. Everything's changed in the last 6 years or so. So we want to make sure the clients have had specialist advice before they start drawing, before it is too late. And we'll come on to the detail of that in just a moment. But I say that, and I'm saying this isn't financial planning advice. I think I've put this on my next slide. In fact, just to come to the end of my next slide, which is on ISAs. But I've said at the bottom of this slide, neither of these cases are we giving financial advice. I know that lawyers, we can't do that. We're simply saying you've got to stop and take advice before it's too late. And the second of those situations is with ISAs. And it's so easy if you're dealing with an estate administration, you're winding up the estate and there's a lovely great big ISA which has got $500,000 or more in it, and the ISA manager will often just say, I now just cash that in. It's an easy thing to do, for particularly if you've got a more junior member of a team who's dealing with the routine estate administration, just to give the okay to go ahead and do that. It is simple, but it's not necessarily right. So again, you want to say, stop. Have you taken advice? Might you want any of the individual stocks or shares within that portfolio? We'll come on and see in part 7 in just a moment the possibility of having the ISA actual investments. And if you want to have the underlying investments rather than simply the cash, then you want to inherit them and you want to transfer it across. You don't want to cash it in. So that's another scenario to say, stop, take advice before you do it. There's lots of things there, but there is big financial planning need to take advice on whether you might want to have this portfolio of individual stocks and shares with all the risk profile that goes with them. Do you want to have that? Get advice before it's too late. Any comment, Hannah?
Yes, I would definitely.
Sorry, yeah.
I would definitely agree with what you've said there, and I would just add, sort of from another slightly different perspective, when we're looking at it from a financial planning side, is to try, and I mentioned right at the top that we try and be, well, we are impartial, but we try and really always strip the emotion out where we can of some of these decisions. Behavioral finance is something that I find particularly interesting, and some of the emotional factors and drivers that can come into decision making for individual clients that often can lead them to decisions which perhaps objectively are not in their best interests. And that particularly comes into focus with inheritances where they might be dad's shares, they're dad's shares, he chose them. And there is that, it sounds a bit silly, I think, sometimes in the abstract, but people do, you see it time and time again, they hang on to certain investments or certain assets because of why or how they came to be held in the first place, despite the fact that if you can take a few steps back, they're not appropriate or they're not suitable, or maybe they should be changed. So I think John's point here around saying, stop, let's take a step back, let's look at this objectively for, you, the new client, not the person who's passed away. How do we set this up for you so that it's going to work for you going forwards, while taking into consideration their wishes and how things have gone before? So I think it's quite an important point.
Thanks, Hannah. Lovely. So 2 more slides in this part 6. So again, we're looking here at the RBN threshold, the £2 million, and so this is just a reminder that the pension death benefits written in trust are not part of that 2 million, provided you've only nominated the benefit and have not got a binding nomination. I think we've made that point now. Hopefully everyone's happy with that. And therefore, can we look to spend or gift capital over the £2 million limit, and draw down towards so that you come below the 2 million by the time you're looking at the estate? And I think it's important to draw to clients' attention the 60% tax rate. the band of capital over the £2 million threshold in practice faces a marginal IHT rate of 60%. When you put together 40% IHT plus the loss of RNRB on that element over the £2 million threshold, it's effectively a 60% marginal tax rate. Historically, that's a very high rate. It even beats that 55% on the old pensions. So it is one we want to try and avoid if we can, with sensible planning. And absolutely important in this is the cash flow planning to try and get clients to see how this is going to work for them, and to see with the cash flow whether they can spend other assets. I mean, I'm not naive about this. I've over the years had many clients. Spending capital is an anathema. You know, it's totally, you know, for an older generation, totally out of verboten. But actually, many clients can be encouraged with a cash flow planning, a cash flow analysis, to see that actually they spend that and leave the pension to be passed on by flexi access drawdown to the rest of the family, and that actually can work well. I've said down the bottom, many financial planners are giving this advice already. I mean, it's a big part of financial planning advice, or should be, and you know, and so most clients who are getting up-to-date advice should be getting this, but it's really important to factor this into the whole equation. Anything else to say there, Hannah, before we go on?
No, nothing in particular. I completely agree. It's where the cash flow can come into handy, and it's just unpicking sometimes those unconscious almost decisions and those patterns that people fall into, the received wisdom of, oh well, I need to carry on taking £1,000 a month from the pension so I can put £500 a month into savings, and that being horrible from a tax planning perspective. So it is just sometimes it's unpicking that and taking that extra step back and saying no, maybe not.
Absolutely, and as we say at the bottom of this slide, this is where legal, tax planning, and financial planning really do come together to as part of getting the right result for clients. So as we're into our last quarter of an hour now, we've got some slides on estate planning for spouses, and this is where well, I mean, first of all, we recognise there is, of course, a huge role for wills and for the trusts and what you're doing with other trust arrangements, no-rate-bound discretionary trusts, IPDIs, and so forth. That's a big part of it. But as that's not part of the scope of this course, our focus is on the second part of this, and we're then saying, you know, let's revisit our objectives. And I've set out here the four things, the third one being mitigating IHT, and the fourth, the right division of assets at the end of the day, and trying to keep those things in balance. Always important to keep coming back to that with clients to see how that works. We're going to go on and look at the ISA examples, but Hannah, do you want to add anything on slide 7.1 just for now?
I think we can just move on from that one.
Good, lovely. So let's just look at ISAs then, and just remind ourselves that with ISAs, the big new the last few years, tax planning opportunity is the opportunity to inherit your late spouse's ISA, or to claim an extra ISA on the death of a spouse. So in looking at this, this is a classic legal, tax and financial planning scenario, looking at all these elements together. We need to be aware with the legal side of what's in the will, what does any trust say, what any letter of wishes say, about the beneficiaries, the family relationships, and the potential consequences or complications if there's any change to a trust, which I'm going to suggest as one of the options in just one moment. But from an ISA point of view, from a tax point of view, ISAs have two particular tax advantages, of course, which is tax-free income and gains. And I see that Paul put a question in the chat box about using other things before we use ISAs. I think probably that's with reference to the issue about the fact that you don't want to waste your tax-free income and gains if you don't have to. So absolutely spend other resources before you spend your ISA and waste your tax-free income and gains. But I've made the point at the end of this slide, of course, this is not an IHT benefit, it's an income and capital gains benefit. And that's where you want to liaise with your tax advisor about how much somebody is using their capital gains, the allowances. You know, everyone's got a 12.3 exemption a year, so you know, are they using that anyway, and so on. But let's look at some of the options that we may have with our ISA, and to say, what are the financial planning elements? Does the client want to keep the actual investments in the underlying ISA, or do they only want cash? I mean, when your client goes to see Hannah or their financial planner, if the answer is, I just want it simple, I just want cash, then we don't have to worry about any issue about the ISA being inherited, as we will see in a moment. You can, as I say in the middle of this slide, apply for an additional permitted subscription, the APS. If you want some jargon, here's some more jargon, an APS. You can apply for a new APS with cash up to the value of the deceased spouse's ISA. And that doesn't need anything else. Whatever the deceased had, if they had 500,000, you can apply for an extra 500 if you've got that cash. But if you want to keep the actual investments, if you want those to be transferred to you, if you want the underlying investments that have been built up, and if there's good reason for them, not just the sentimental reasons that Hannah was alluding to just now, but if you want to inherit them for good investment and financial planning reasons, then you have to, there has to be something more. You have to inherit. And that means we've got these choices. If it was that the ISA is part of an estate which is in an IPDI trust, for example, it's in the residue which is going to on trust for a spouse to have an income, so there's an income entitlement only, then it may need to be advanced out to that spouse, absolutely. Or it might be in a discretionary trust, for example, in a nil rate band discretionary trust, and then it could be appointed out of that so that the spouse has that capital, absolutely. In either case, the end result of that would be the ISA can be distributed in specie, with the spouse taking the shares, the underlying shares, into their own ISA. And the point there is the ISA manager has to go straight from the deceased spouse's ISA into the surviving spouse's ISA. It can't come through cash in the middle. It's got to go across from one to the other, and not be transferred out to the PRs first. So there may be a case for looking at this and looking at actually having this arrangement if it works altogether. But of course there are big legal and tax consequences of taking it out of an IPDI trust or taking it out of a discretionary trust, and we have to be conscious of that and have to think about how this is all going to fit together. So we are these remaining slides will then just try and bring this all together and look at the whole thing. We want to look at what each spouse has got. If you're only acting for one of them, what's the other one got? And can they talk together and liaise together so that they're aware of how their assets are going to work, both those that are producing income and capital growth, and those that are producing, that are largely for use, for occupation. Have they got a financial planner? Can they have a financial planning review now to take stock of everything? This is the classic time when you're, the two times when you're planning during their joint lives, but also after the death of the first spouse, to take stock and to see with a financial planner what you've got and whether we can actually look at the use of the assets in a more tax efficient way. We want to try and look at all of these elements. What's the R&RB position? What's the pension position? And what's the ISA? To see this whole picture in the light of these big changes. All of these things have changed in the last 5 or 6 years, and all of these things have a major potential impact upon what you may want to do in your estate planning with spouses. And one of the things that you may want to do is to look at this whole picture, and dare I say it, use the word holistically, but to look at the whole picture to try and ensure that we bring all the different elements in to achieve balance and fairness. But in looking at that, this is one scenario that might work in some cases. It might be that the ISA gets transferred to the spouse. If it was, for example, in an IPDI trust, that it gets transferred out, so the spouse can actually inherit the investments, the underlying investments there, and also have more capital in their own name. Obviously spending their non-ISA capital first, but then when you've spent down that, or you want to keep a certain cash reserve for immediate needs and so forth, but to at some point start drawing down your ISA capital. At the same time, releasing the pension so that it can be designated to draw down to the next generation, to the family, so that the family who are not now necessarily going to get the capital that's tied up in the IPDI trust because that's been released to the spouse, but instead they are getting the capital from the pension. So we're looking at this as a whole and looking at how all of this is considered together, and the kind of the whole arrangement. I don't want to use a word like doing a deal, but it's kind of looking at the whole picture about whether it might make sense in some cases for the spouse to get the ISA and for the family to get the pension, and to have the pension death benefits. So that's just to give you one example of when you look at the whole thing, how you might see it together. Obviously, as I say here, that example has important legal implications. We do need to think about all those things, about the balance between the families, about who's going to get what, about all those issues we've mentioned already about people who there may be issues about potential family divorce, financial issues within families, and the question of asset protection. But if we can work together, this is where I do feel working together at estate planning, the legal, tax and financial planning come together, we might be able to achieve a better result here. And as I say, to sell to the client the value of this, the value of the integrated advice. I see we have some questions in the chat box, but Hannah, a little comment first. Do you want to say anything?
Sorry, I was reading the questions in the chat, so they were coming through. But no, I don't have anything more particularly to add. I think you've sort of covered everything that I would.
Great. Okay. Margaret says, if a minor were nominated as a potential beneficiary under a pension plan, would the pension scheme join in settling any beneficial and any benefit into a new trust for the benefit of the minor, or would it be more usual for the income to be paid, say, to a parent or guardian of a child during minority?
Yes.
Hannah?
So what would often happen, what would be the most usual case, is if the benefits going to a minor beneficiary, often what the pension trustees will look to do is to pay out the sum as a lump sum, and then that effectively goes into a bare trust. Now, that's where the trustees may differ. Some of them may pay it directly to the guardian for it to then be used as they see fit. Others might want there to be a specific trustee set up before they will pay the benefit out. That's my understanding of how they would usually treat that. But effectively, it would usually get paid out as a lump sum to the guardian of that minor. So it could be a parent. Does that answer that question? Gail, if you want to put in the chat whether it does.
Thank you, Margaret. Do come back to us if you want to follow that up. Laura asks the question, clients often come for wills and estate planning with what they hope will be decades left of their lives. And given how generous I have said, I think the current death benefit provisions are, how far in advance would you feel comfortable using this in the planning and therefore taking into consideration into a will? That's a good question, Hannah.
It is a good question. John, are you going to answer?
Well, I mean, I think the great thing is two things here. One is to keep things under review and to encourage clients not just to make a will and a structure and leave it in place and just leave it, but to the 5-year review of the will and the whole arrangement seems to me to make a lot of sense. But I think the cash flow analysis comes in very handy. And if you've got somebody who is kind of 55 and they're widowed young, the cash flow analysis seems to me can be really helpful in helping somebody to see what they've got and what how long it might last and so on. I mean, would you what would you say about that, Hannah?
Yeah, I mean, I would certainly be looking where somebody is, relatively young and has decades of their life left, trying to retain where possible some flexibility. One of the really nice things with using pensions in this context is how flexible they are in terms of both paying out income in their lifetime and also paying out income on death and providing benefits. So if, for example, a client had a large pension and other assets that they could draw on, well, on the basis of as it stands today, I think you'd be right and proper to recommend that they perhaps draw on non-pension assets now and preserve those pensions. But if the legislation changes, then we could switch that round. If suddenly ISAs leapfrog pensions and become the better thing to leave, would switch off the ISA income and switch to pension income. It is nice and flexible in that way, so we're not necessarily having to make really binding decisions. And again, it comes back to John's point, which he's made a few times around needing to regularly review the financial planning and the tax and the legal paperwork as well. And one question we always ask in our review meetings with clients is, have you updated your wills, but also when did you update your wills? In much the same way as, did you last do your financial planning 7 years ago? If you did your will 20 years ago before you had kids, we're going to be saying you need to go and talk to somebody again to update that. So we definitely would always be keeping it under review as things can and do change with clients' lives as much as with legislation and the scheme rules.
Kieran, I see that we've just hit 2 o'clock. So do you want to step in as chair now?
We have indeed, and I think just to add to those final points as well, I think it's about imparting knowledge to our clients. If they're not aware of the particular benefits that either come from the ISAs or the pensions, it won't even feature, in their thoughts or in their minds as to what opportunities may arise. And combined with then general reviews, certainly at least every 5 years, there's a great opportunity for the client to get the actions in place at the right time and in the right circumstances. So I would echo an awful lot of what's said there. So Hannah and John, thank you both for putting together a particularly interesting and relevant and increasingly relevant course that crosses both sectors in terms of the legal and the financial. It's becoming evidently clearer that the advantages for clients in working together across both disciplines really does add value. Having the knowledge and imparting the knowledge around, the art around letters of wishes or getting the nominations right, and one of the big take homes, Hannah, was that form, the form that could take your pension out of taxation into taxation. I'm not sure I would have spotted that. So that's a really useful health warning. I can also add sentimentality points regarding dad's shares. It's amazing how often we see that, how someone attaches sentimentality to a piece of paper is difficult for me to appreciate, but it happens more than I think we care to imagine. And I think also, just finally, that 60% marginal rate, that is something that clients are going to sit up and listen to as they exceed that 2 million. And I think, when we start to get that message across that we can really assist in removing that marginal rate from their estates, really, and I think it is the sweet spot is, from the 2 to 5 million, it is possible even with house prices in this part of the world. And there's a lot of value we can take back to our clients and back to the desk. So Hannah and John, thank you very, very much once again for an enlightening afternoon.
And Kieran, could I just interrupt just to say a quick thank you to Rishi Sunak, because he's left inheritance tax rates and everything intact. So just to say, if you haven't yet seen the book, it is the Law Society's IHT Planning Handbook. You know, it is there, and I don't get any commission for mentioning it, but thank you, Mr. Sunak, for not actually changing any of the rates. All the figures are still the same. All the planning is still basically good planning. So there it is. And also just to say, there is a little disclaimer there from Tilney at the end. So that's the end of our slides. Thank you.
Thank you all.
Yeah, thanks, Kieran. Thanks for chairing.
You're very welcome. Just final points, do send any feedback to helen.op@surreylawsociety.org.uk, and a link with the recording will follow to all attendees over the course of the next few days. So John, Hannah, thank you both once again. Have a fabulous afternoon, and thank you all for attending.
Thank you, everyone.
Thank you.
Thanks. Bye.
Bye-bye.